Access Minnesota. Issues that matter to you. Access Minnesota brings you the newsmakers and the stories that shape our everyday lives, with analysis from University of Minnesota faculty experts.
Americans first became familiar with the term affirmative action in 1961. President John F. Kennedy issued an executive order to government contracting agencies. It required them to implement affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. Affirmative action in the 1960s was intended as a tool to battle persistent discrimination against African Americans. It has since expanded to include other racial minority groups, LGBT, women, and people with disabilities. But starting in the 1970s, the Supreme Court began hearing cases that challenged the fairness and constitutionality of affirmative action policies. How can affirmative action policies best ensure fairness and promote opportunities for minorities without blatantly using race as a factor? The Supreme Court continues to this day to hear cases that grapple with this question, including the current case awaiting a decision, Fisher versus the University of Texas, where the issue of whether race can be a determining factor in college admissions will be decided. This month on Access Minnesota, we look at the history of affirmative action and specifically its controversial role at universities. We examine how the Supreme Court has decided affirmative action cases in the past and try to understand why this issue has been battled in the courts for more than 30 years. Later in the show, Access visits the Office of Equity and Diversity at the University of Minnesota and discusses the importance of diversity in higher education, how the university sets its goals for a diverse campus, and what challenges minority students face on campus. But first, Access talks to political science professor Timothy R. Johnson to learn more about the Fisher case and what impact the decision will have on admissions policies. Timothy R. Johnson is a Moores Alumni Distinguished Teaching Professor of Political Science at the University of Minnesota. Timothy, welcome to Access Minnesota.
Thanks for having me. I appreciate it.
The U.S. Supreme Court will soon decide on a case concerning affirmative action. It's Fisher versus the University of Texas. Tell us more about the federal affirmative action laws and how they relate to admission policies at public universities.
Sure. So since the Supreme Court decided Grutter versus Bollinger in 2003, the federal law, the way that we view whether affirmative action is constitutional or not, really comes down to one factor, and that is that race may be a factor in an admissions process. We don't allow quotas. We don't say that there should be X number of African Americans, X number of Hispanic Americans, X number of Asian Americans, and X number of whites. You can't have quotas like that. But the law now says race can be one of those factors taken into account when deciding whether to admit someone to a college or a university.
Professor Johnson, let's talk about the specifics of the Fisher case. The case centers around Abigail Fisher. She's a white student who was not admitted to the University of Texas. Now, she claims the decision not to admit her was based upon race, the fact that she was a Caucasian. What are the admission standards for the University of Texas?
Sure. So the standards at the University of Texas were changed, interestingly enough, changed the exact day that Grutter versus Bollinger was handed down in 2003. It seems as though the University of Texas was anticipating that that may be the decision in that case. That day they changed the standards to the point that 75% of all applicants, in fact, are admitted right off the bat to Texas. The way that this works is, if you are in the top 10% of your graduating class in your high school, you are automatically admitted to the University of Texas. Now, that's only for Texas students, not for students nationwide. So if you're a high school student in that state, top 10%, you're admitted. In fact, I don't think you even need to file an application. They just are going to allow you admittance, okay? That gets you to about 50% of their enrollment. The other 25% of their admittees fall into this other category where you take into account what normal admission standards take into account of. Your grades, your test scores, your leadership skills, what sort of activities you were involved in, your socioeconomic status, and finally, one of those factors that the Supreme Court said you can take into account of, race. Now, Ms. Fisher fell into that category. She was not, I believe, in the top 10% of her high school graduating class. She fell into that category where you needed to apply, you took account of all of these different factors, and ultimately she was denied admission after submitting an application, and this became an issue at the oral argument, paying for that application process. And it was unclear exactly why she was denied. She was denied. The University of Texas, like the University of Minnesota and other colleges and universities, don't give reasons why they deny your admission. And I'll give you an example why. There's between 35 and 40,000 applications to the University of Minnesota a year, and there's an equal and maybe a little greater number of students who apply to the University of Texas. It would be virtually impossible for the admissions office to give you exact reasons why. Her argument was because she was a Caucasian student and she didn't have that uptick, if you will, from race. That is, it was one of those factors. That's why she was denied admission.
Now, what are the arguments that are being presented to the court that would be against the university's affirmative action policy beyond this particular situation? Does it just simply affect her case, or are there broader issues?
Well, it's interesting because if you listen to the oral argument that took place last Wednesday, the Supreme Court was sort of divided on that issue of whether or not this case is a narrow one, it's only about Ms. Fisher, or it's a broader one. Should we reconsider our decision in Bakke versus the Regents of the University of California, the famous affirmative action case from 1978, as well as reconsider the Grutter decision from 2003? It's unclear what the justices want to do. The arguments made by Ms. Fisher's attorney were really focused only on her, but the liberal wing of the Supreme Court, or the liberal moderate wing, Justice Sotomayor was the most prevalent questioner on this issue, and that was, no, I think you need to tell us whether we should decide this case more broadly or it should be viewed more broadly.
What kinds of questions have the justices been asking during the oral arguments? You just mentioned a couple of them. And from these questions, do we have any indication of which way the court is leaning on this case?
Sure. So it was interesting. The oral argument began not talking specifically about affirmative action. Justice Sotomayor and Justice Ginsburg interrupted Ms. Fisher's attorney almost immediately. He was only about 35 seconds into his argument, and they wanted to talk about whether or not Ms. Fisher should even be in the U.S. Supreme Court. That is, did she have the standing to be there? Now, that's an interesting question, and the way that the two justices put it was this. One, Ms. Fisher already has a college degree. So what would be the remedy a court could give her? There is no remedy because she's not going to go back and run the gauntlet, if you will, to go back to the University of Texas and get a second bachelor's degree. She already has one from a different university. The second argument that they presented was, in fact, that the court has never allowed an individual to use race as a factor to suggest that he or she has standing in the U.S. Supreme Court or a federal court more generally. And Justice Sotomayor and Justice Ginsburg pointed to some precedents. They were very quickly jumped on, if you will, by Justice Scalia, who said that's not the case. This case does present an issue where the litigant, Ms. Fisher, has standing. And after that about 2 to 3 minute exchange, they moved on to the merits of this particular case. There were several very compelling portions of this argument. The first portion was where Ms. Fisher's attorney argued. Justice Sotomayor actually got to this issue right at the end of Mr. Ryan's argument. He was given 10 minutes of rebuttal at the end of these 60 minutes, and she finally got to her point that she was hammering at several instances throughout the argument, and that was, she said, you are giving us two choices: overrule Grutter or gut Grutter and not overrule it. And he didn't want to go down that road. He didn't want to say, yes, we want you to overrule it. He was not willing to say, yes, we want you to gut that law that says, you know, it's okay that you take race into a factor, yet he wanted the case to be won for his client. And so he really wasn't able to give a good answer. And I think that really dissatisfied Justice Sotomayor. I think the most compelling part of this oral argument, however, came from the Chief Justice. And there are points at which he sounded very annoyed for the University of Texas's lawyer, Mr. Garr. And he wanted Mr. Garr to tell him if race is a factor, and if Grutter's analysis that said we want to use race as a factor until we get to a critical mass of having minorities represented at a particular university, in this case Texas, what is a critical mass? And Mr. Garr and then Solicitor General Verrilli couldn't really answer that question. I'm not sure it wasn't that they couldn't, it's that they didn't want to. They didn't want to put a number. They refused to say 5%, they refused to say 10%, and the Chief Justice and then Justice Alito were more and more annoyed, and they asked 3, 4, 5 times, what is the number? Tell us how many we need to have. They didn't want to give that number, but then you step back and you hear Mr. Garr argue in response to a question to Justice Breyer. He said, look, before Grutter, we had about 5% African Americans represented at the University of Texas. And that's in a state where the population of African Americans is 12% or so of the entire population of the state. After Grutter, you pushed up African American admissions to almost 10%. And so while we're not going to say critical mass is 10%, you saw that there was a pretty decent effect from those cases. That might be the most critical part of that argument, with the exception of one other justice. And that is the be-all, end-all justice, and that's Justice Anthony Kennedy. He dissented in Grutter versus Bollinger. He was unhappy with the idea that you could set any standard that said race could be taken into account. And while he was very sort of quiet at the beginning of the oral argument, when the University of Texas's attorney came up, he really started hammering him at how far can we go? At what point should race not be a factor anymore? And while he didn't give a full indication that he would rule against the University of Texas, his answers were leaning that way.
What is at stake if the court does decide in favor of Fisher?
I think it depends, again, back to one of your first questions and how they rule. If they say this is an instance where one woman's equal protection under the 14th Amendment was violated, then they could rule very narrowly and simply say, we won't overturn Grutter. It's a precedent that has enjoyed pretty widespread support within the United States, within the legal community, and we're not in the business of overturning our precedents, and in particular, very high profile, high salience precedent on a very regular basis. Okay? So they could say, no, this is just a simple, very narrow case and they don't do anything else, and then this case doesn't have much precedential effect. On the other hand, if the 5 conservative justices on the bench, and that would of course include Justice Kennedy, say, no, we want to make a broader ruling here, we are going to overrule Grutter, or in Justice Sotomayor's words, we're going to gut the Grutter decision, then the affirmative action policy in this country is fundamentally changed.
If the latter scenario happens, it is a broader-based ruling. Is that going to open the floodgates for opponents of affirmative action?
You know, I'm not sure that it'll open the floodgates in the legal community. You, of course, will probably see an uptick of cases in federal courts as well as in probably some state courts. The Supreme Court probably won't take many more cases. They'll say this is the final word on this particular issue. What you will see as an effect is most likely a decrease, at least for some time, in the number of minority admits to major colleges and universities, and even minor ones throughout the United States. Now, the question will be whether or not that's actually a correlation from the court's decision, but the odds are, and policymakers as well as policy analysts suggest, that without the Grutter idea of taking race into consideration, you will lose some diversity on campuses.
When Access Minnesota returns, more of our conversation with U of M political science professor Timothy Johnson.
Access Minnesota will return after these messages.